This is one of many issues we have raised through Access Reimagined. The Queensland courts are not built for justice. They are built for processing. If you are autistic and step into a courtroom as a defendant, the system does not see you. It erases you. Legal aid, the so-called safety net, too often fails those it exists to protect policies intended to support vulnerable defendants, such as the Legal Aid Queensland Act 1997, and the Guidelines for Disability Grants frequently fall short in practice. Autistic people are denied representation because the criteria are rigid, narrow, and often do not account for neurodivergence. This leaves defendants with no guidance, no advocacy, and no shield. The result, people with disability are dragged into courtrooms without defense, and many are prosecuted for offenses they never committed. They become victims of the very system meant to protect them. Inside the courtroom, the support offered to autistic people, like intermediaries under the evidence. Act 1977, or court support officers, is often tokenistic. It is insufficient, inconsistent, and sometimes unavailable. Judges, lawyers, and staff rarely receive training on autism. Communication is not adapted. Court environments were not modified to reduce sensory stress. Defendants are not treated with dignity. Instead, the system demands that autistic people conform to rules, procedures, and social expectations that are fundamentally misaligned with their neurology. Here is the deeper truth. Autism and the law do not correspond. Legal frameworks assume neurotypical comprehension, social reasoning, and response to stress. Judging autistic people under these rules is often unfair. Courts ignore how autistic people process language, interpret social cues, or respond under pressure. Difference is criminalized. Sensory overload is mistaken for defiance. Confusion is interpreted as guilt. This mismatch is exploited. Police and prosecutors often leverage procedural pressure, prolonged custody, delayed hearings, and repeated questioning, tactics that can overwhelm any person and are especially damaging for someone with autism. Overload, anxiety, and sensory stress become weapons against the defendant. This is not justice. It is abuse wrapped in procedure. Until Queensland courts and legal aid are compelled to recognize disability rights, implement mandatory accommodations, provide consistent representation, and offer genuine training for all staff, autistic defendants will continue to be sacrificed to a system that thrives on their vulnerability. Access Reimagined calls for systemic reform, enforceable accommodations, proactive legal representation, and meaningful inclusion of neurodivergent voices in policy. Anything less is a perpetuation of harm.